Good evening. When the Home Secretary Theresa May made a statement to the House today outlining fast-track legislation to ensure police and security services can access mobile and internet data, she did so secure in the knowledge that she'd square the opposition. Her Labour shadow Yvette Cooper and party leader Ed Miliband wrote to their MPs today saying they'd been guided by their firm conviction that it was essential to maintain the security of our citizens and also ensure people's privacy is protected. But not all politicians and campaigners are so sanguine. Here's Jim Reid.
2006, and a plot that caused chaos at airports across the world.
You have nothing but to expect a flood of marked operation, volcanoes of anger and revenge erupting amongst your capital.
In the end, 3 men were convicted of trying to blow up planes with liquid bombs, a plan uncovered after tapping into phone and internet records. From the killer of Rhys Jones to the men who groomed girls in Rochdale, the government claims all could have gone free without the power to monitor electronic communications. David Cameron says it's a power that could disappear after a recent European ruling, and an emergency law is now needed.
Now, we face real and credible threats to our security from serious organised crime, from the activity of paedophiles, from the collapse of Syria, the growth of ISIS in Iraq, and al-Shabaab in East Africa. And I'm simply not prepared to be a Prime Minister who has to address the people after a terrorist incident and explain that I could have done more to prevent it.
The police and other government agencies made more than 500,000 requests for data from communications firms last year. This is so-called metadata, the raw information that shows who is contacting who, for how long, and if on a mobile, where from. There were another 2,760 requests for interceptions. That would be the content of the actual phone call, email or message.
It's an essential source, I think, both countering terrorism and dealing with serious crime. Particularly for law enforcement, this is an essential tool. And a lot of it's very basic. It's who called whom, when and where, basic communications data. So it's really important that that capability is maintained.
In the aftermath of the Madrid and London bombings, a European directive was put in place, forcing companies to store customer data for up to 24 months and hand it over to the authorities when needed. For years, that wasn't questioned. But the leaks from this man, Edward Snowden, have changed the way that some members of the public and some companies feel about state surveillance. In April this year, the European Court of Justice ruled that those firms no longer have an obligation to store that data. Privacy campaigners say they have already sent more than 1,500 letters out demanding that all personal information is immediately deleted.
Without this legislation, we face the very prospect of losing access to this data overnight.
That appears to have caused a panic in Whitehall and the sudden realisation that the police and security services could be on the back foot. Today's emergency law will override that European ruling, effectively restoring the status quo. The new law is unusual for a number of reasons. The speed it will be on the books, for one. It should complete all its parliamentary stages by next week, and the way in which it has the backing of all 3 main parties before it's even been debated. Long-time critics are suspicious, accusing the government of a stitch-up.
If there was a real emergency, it would have been on April the 8th, when the European Court actually made the ruling. Then you would have expected the government to come to the House and say we need to have an emergency law if that's what was necessary. They should have seen that coming. Instead, to rush it in 1.5 weeks before we end the session, it doesn't seem to be sensible.
Nick Clegg was at David Cameron's side today to support the measures. On paper at least, the new bill does have greater safeguards, a new oversight board and the promise of a review before the next election.
Crucially, we've inserted a poison pill, if you like, into the legislation. It will fall in December 2016. We are not putting anything permanently on the statute book.
But the bigger question is what happens after that date. The PM made clear today he would like to go further, giving greater powers to the police and security services. Even those who've worked on the front line need to be convinced that's really necessary.
I think the Act is pretty good. It's technology neutral. It's enabled the authorities to collect information which has saved lives and prevented crime. So I'm not personally convinced that there's a huge new area that is needed.
Since Snowden, there's been pressure on the state to roll back its ability to snoop. Today marks a new stage, an attempt to draw a line and set out why these powers are so necessary. Even the politicians admit that getting the balance right between security and privacy may take some time yet.
Jim Rewell joining me now, the Justice Minister and Liberal Democrat MP Simon Hughes, and Shami Chakrabarti, Director of the campaign group Liberty. Simon Hughes, first of all, it's a massive climb down for the Liberal Democrats and just another example of throwing your principles to the wind to remain in the coalition.
Completely not. Completely not, because it doesn't increase the powers of the state at all. It doesn't agree to the Snoopers Charter, which we have resisted and has not been agreed by the coalition. And although the Tories would like it, we haven't agreed to it. It doesn't pick up some of the ideas that were advocated by the last Labour government.
So why so last minute? Why so, I mean, what David Davis is saying is there has to be some kind of debate in this. You've had 3 months.
You asked me a question saying, is it a big climb down? And I was just saying that not only is it not because it doesn't change the present law in terms of its impact, it also, as you heard Nick Clegg say, adds a huge amount of extra things. We have got a guarantee, we have secured a guarantee that the big law, the Regulation of Investigatory Powers Act, will be reviewed before the general election. We have secured that this piece of temporary legislation has an absolute end in 2016. We have secured...
Are these big concessions? No.
They're all additional things. They're all addition.
But
they're all better safeguards.
You do accept that the terror threat, the threat from criminal gangs, threat from is often online.
Absolutely. I'm not going to have all this nonsense that I heard from my Prime Minister today about this emergency being caused by paedophiles and jihadis. This court judgment that found the existing regime unlawful, a disproportionate blanket interference with everybody's privacy, whether you're a suspect or not. This judgment came down on the 8th of April of this year. I've read this bill today very carefully, and it's a very short piece of enabling legislation that could have been introduced into Parliament pretty much 3 months ago. So what is the emergency? Why has it taken 3 months? Because they've been stitching up a little deal with the coalition and, it seems, with the opposition behind closed doors. They talk about committees of oversight. Why can't Parliament be the committee of oversight?
Parliament will be the committee of oversight because Parliament will have an immediate...
3 days to do this.
Shami, you've looked at the bill. It's a very short bill. You've conceded that. You would concede...
It took 3 months to draft.
Let me deal with one point at a time. You would concede, I hope, that the bill does not extend the powers of the state at all. What it does is
reverse the judgment.
Replace by a piece of legislation the secondary legislation that was in existence under the directive. So it doesn't change the law, it doesn't add to the law.
Why so last minute?
The answer to that question I can give you is because we were very careful that once the judgment of the European Court was given, we didn't want to get legislation wrong. Careful attention was given to make sure we had the minimal amount of legislation to replace it. That's why this, and also for us, that many additional safeguards were put in place.
Absolutely.
Who's utterly changed their position?
That speech from the Deputy Prime Minister and the Prime Minister today could have come from Tony Blair or Gordon Brown or any previous minister.
But hang on, Shami.
You would not have supported this before the general election.
Shami, it couldn't.
You would not, Mr Hughes. Minister, you would not have done.
Because you heard what the safeguards are. The safeguards are a review of the substantive legislation, part of it interim review.
2016. Why so late?
Listen, there's a review of the main legislation. There's a new oversight board. There's a change in the scrutiny committee in Parliament. There's a sunset clause which kills the bill, doesn't enable it to be reviewed. There is a huge reduction. Kirsty, there's a huge reduction.
But wait a minute, what about your own personal policy on this? You were against the Communications Data Act. You didn't want any of this stuff.
And it's gone. We have stopped it. The Tories want it. We have stopped it. And Kirsty, the really important thing is this bill reduces the commitment we've got, reduces the number of authorities who can ask for data. It does.
It's only such a short time since Lee Rigby when you said that this was all knee-jerk reaction, and now what we're having is a very last-minute piece of legislation.
There is no emergency.
No, there's not knee-jerk reaction. If it was knee-jerk reaction, you would have seen something brought to Parliament, as David Davis mentioned, the day after the judgment.
But Shami,
there hasn't been any knee-jerk reaction.
There is something to say about this, because actually in the same way that you're attacking for such a, the idea that there's very little chance to have any oversight of this, in the same way there doesn't appear to be any public outrage, because the public believes, by and large, that the government is doing what it can to keep people safe from terrorism, from paedophiles and from organised criminality, and that is the duty of the government.
Absolutely. Do you know what? I agree that this kind of data can be really, really helpful and essential in all kinds of serious criminal investigations. I'm sure the Court of Justice agrees that too, but they found this blanket surveillance, this blanket retention and access to data, all those thousands and thousands of requests, they found that disproportionate. And this bill creates no safeguards that ensure that the regime is more targeted and that we go back to being citizens and not all of us suspect.
Which is why, Kirsty, the legislation, very short legislation, makes it clear that the Secretary of State will only have power to issue necessary and proportionate interception warrants. The whole proportion issue is very important.
But that's nothing
new. But then if it's proportional and everything else, why are you making such a fuss about the idea that there's some kind of sunset clause on this? What is going to change 2 years down the line to suddenly suggest that you will not support the continuation of this legislation?
There's a big debate about this issue, rightfully around the world. I'll give you one example. I'm a member of Parliament in the constituency where the little boy, Damilola Taylor, was killed, and his killers were found because people were able to track the communication patterns on mobile phones. Yep. So I don't think there's any disagreement. No, I don't think there's any disagreement that we need to be able to track these data patterns. If that's the case, when the European Court says the legal infrastructure that you have is not valid, what do? Do we stand back and do nothing?
And you haven't been targeted enough, you've been too indiscriminate.
Or do we put in a holding operation bylaw, keeping not expanding the powers of the state?
A holding for 2 years, but not
That's
over...
quite a long hold.
But hang on.
Plenty of time to look at what we want to do properly, both in this Parliament and after the election.
It's fair to say, Shami, that you have an opposition to this, but what you don't know, because you're not a technological expert, is how quick the technology is moving. We know by the various things that are happening with airport surveillance now that things are moving very quickly in technological terms, and therefore presumably we have to do everything we can to cover the waterfront on this.
The technology moves apace, but the law and the politics has to keep up, and the way to keep up is not to give
But
this is just giving a blank cheque to the executive to reverse court. This is contempt for court. No, let me finish. This is a contempt for the court because it reverses the court judgment and doesn't put in the safeguards that the court required to be more targeted and more proportionate. And it's contempt for Parliament because they're going to pass it in 3 days next week.
Shami, if this was
contempt for Parliament, 3 days.
If this was a proposal to increase the powers of the state,
you're reversing the court's judgment.
Of course. Shami, when a court judges...
Are you not reversing the court judgment?
We're not reversing the court judgment. We are dealing with the fact that the regulations that we have, secondary legislation...
Are you responding to the court judgment,
Of course we're responding to the court judgment, you know that. And the regulations that at the moment we have may not stand a test. So what should we do? Should we neglectfully say, it's all right, we'll leave it to be legally tested and have no law? Of course we shouldn't, because we could be left with no legislation at all to make sure that the security authorities kept the data which we need to keep this country safe.
Thank you both very much.
And Parliament will be able to do with it.
Thank you both very much indeed.